What I don't want to do is to try to introduce the nitty gritty and nuanced details of this white paper that has been a work in progress for some 2+ years. What I want to do is highlight the major issues and major agenda items that caused us, that drove us to work on this project and build this project, and take an example of the way in which following the direction, the what in Hebrew we call the kriyat kivun, the call to actions that this white paper and this project have been designed to accomplish, can lead to really, really good outcomes. That's what I want to focus on. So let's move down to slide 2. And talk a little bit about this white paper, which shall be published in the next couple of weeks, maybe months. Basically, this is a result of a conference of Judaica curators that existed online in May of 2021 during the COVID crisis, when it was really not possible to meet in person. And we had a panel, really a round table at that conference of Judaica curators, which was entitled Murky Provenance and the Ethics of Collecting. And that panel really focused on the practice, and I see in those who are attending today so many friends and colleagues who are real practitioners in the field, many of whom attended that and participated in this working group, to kind of put things on the table when you're trying to develop public collections of libraries, manuscripts, books, archives, and the like related to Jewish heritage. If you're trying to be both professional in a public institution that is really focused on preservation and access of this kind of Jewish cultural textual heritage, you are in a bind, because in addition to all of the challenges that face provenance professionals, people trying to trace works of art and culture and their roots and where they came from and how they came to be in particular time, or at the moment, how they came to be where they are, in addition to all of the intellectual and ethical challenges in that field, in the Jewish example, things are particularly difficult, in large part because the Jewish community has moved and changed so dramatically in the last 150 years. Mass migration, expulsions, of course, the mass murder of European Jews in the middle of the 20th century, the founding of the State of Israel, the flight of many Jews, the escape of many Jews from various parts of the world to Israel and to other places over the course of the last 150 years. I kind of jokingly say, if you made a list of the 10 most culturally important Jewish cities in 1874 and compared them to the 10 most important Jewish cultural cities in 2024, you would discover that no cities appear on both lists. And what that means, even whatever the details happen to be, right? There's been so much movement. And what this means is that when you see books or manuscripts or archives on the Judaica market, you are likely not to have any idea what happened to them and how they got to the sale or potential donation that, as a responsible curator of a public collection, you're supposed to deal with. So how do you deal with this? On the one hand, if what you try to do is say, listen, I'm not touching any material unless I have a clean record of ownership, a clean trail of how this legally came to be where it currently is, then I don't want it as a donation. I'm not going to purchase it for the collection. The result is going to be that materials are going to end up in the black market. They're going to end up under the table being sold to private collectors, and public collections will never get their hands on them. And if you go in the other direction and say, well, whatever it is, if it's Jewish cultural heritage, we're just going to grab it, well, then you're going to end up with with looted materials. You're going to end up with materials that have been removed illegally. You're going to end up with materials that were looted by in the course of war, in the course of forced expulsion, in the course of immigration. There are plenty, as anybody who works in the field of rare books and manuscripts knows, there are plenty of people who are, let's just say, not entirely upfront about all the information that they have, whether that's out of dishonesty or protecting their commercial interests, whatever it is. It's really hard to get good information. So what do you do? And at this roundtable a couple of years ago, we sat around a group of professionals in the field and say, well, let's talk about this elephant in the room. We all know that this is a mess. We all making it up as we go along, in conjunction with our senior management, in conjunction with legal advice, in conjunction with, but let's sit down and talk about it and try to write out some guidelines to help us navigate these unsolvable problems, not in order to get the right answers, but in order to give us a vocabulary and shared vision for what we could do, each institution with its own nuances, with its own agendas, with its own risk management, with its own place within the Jewish and library world. Let's have a shared language and some kind of shared vision that can help us make informed, professional, ethical decisions. And what we ended up with, you can see on this slide, a kind of, which I'm not, a theoretical introduction to issues, praxis, which Michelle will talk about in a few minutes, as well as a workflow and bibliography and digital resources. Now, I mentioned the theory, the problem of expanding collections versus ethical considerations, 1A in this outline. And 1B, there's another tension. Because you have so many items, Jewish communities have moved so dramatically in the last 150 years. The result is that one of the core moral and legal principles that motivate so much of the provenance world is problematic in the Jewish case, namely the idea that communal property, public property, cultural heritage is better off in its country of origin. Now, in the Jewish case, there's much to be said for that, for both professional research and cultural reasons, right? An item that was created, let's say, in Iraq, or an item in Morocco, or an item that was created in the Ukraine is linked, whether Jewish or otherwise, to the culture of that place. And on the other hand, when you're dealing with countries that have a fraction of the living Jewish community that it once did, certainly when dealing with countries and areas who were actively involved in the past and might still be actively involved today in persecuting Jewish communities, then it hardly seems like an ethical solution to find Jewish cultural heritage back in places in which Jewish communities will have trouble living. Active Jewish communities, large central Jewish communities, will be marginalized from the agency that they could have over their own cultural heritage. And finally, an issue, and again, this is anybody who's spoken to Arthur will know how central this is to his thinking, is the idea that some of the legal models of ownership can cause more problems than they solve. And instead of, or when possible, it can be really smart not to think only of technical legal questions of ownership, proof, demonstration, evidence, but also what we've taken to call stewardship, which is to say, who are the bodies who have an interest, who have a cultural interest, an intellectual interest, an economic interest in these heritage items, and how can we work together with them to find practical solutions that will result in win-win situations, that will result in the needs, the maximum needs of as many stakeholders as possible being met, especially if you can, and you can't. I mean, the law often deals with ownership and not other categories, but can we work creatively not only to think about the legal aspects of ownership, but also some creative solutions that involve cooperation and collaboration? So briefly, slide number 3, just briefly, just take a look at some people who sat for about a year and a half to 2 years to meet, convene, discuss, read, learn, argue about how we might address some of these issues. We brought in historians, practitioners, librarians, legal experts, digital experts, people from within with more access to the private collector world, people with primarily public institutions from Israel, Europe, the United States. And we sat together, and I really got to say to my colleagues just how productive and respectful, even in the case of disagreements, and how wonderful it was to learn from such a diverse, smart, focused, caring group of people. I want to bring a quick example of what can be done by thinking collaboratively and thinking a little out of the box in the case of these issues. And this slide kind of summarizes some of the things that I had said before, right? We have these known and unstated problems of provenance. Lots of professionals are looking for guidance, are not sure how to behave. There's a lot of material on high-end art and non-Judaica, which is both relevant but often not specific enough for certain Judaic issues. And what we're trying to do is create best practices in the field, focus on creating a larger community of practice for communication between stakeholders, stewardship, responsible stewardship, transparency, and try to make the market as ethical and stable as possible without undermining both legitimate financial interests and cultural interests, and also without driving the market for rare books and manuscripts and archives in Judaica to underground markets where public institutions can't really play very well. A quick example of why thinking in these directions are helpful. There's been, and many of you know about these, I won't get into the details, but a number of what are called Pinkasei Chevra Kadisha, burial society record books from East Central and Eastern Europe. In a couple of situations, after discussions between foreign ministries of various countries, police and homeland security, a number of these that people had thought were going to the market and were likely to be purchased or donated to public institutions, they were simply seized by legal by law enforcement. And I don't know what's eventually going to happen with them, but I do know that the public is not going to get access to them anytime soon. And I want to compare that to another set of 7 Pinkasei Chevra Kadisha, East and Central European record books, and that were put up on another sale, where the particular law, the jurisdictions were different and the law was different. And when this came up, there was a lot of concern, both among communal activists in Hungarian Jewish communities, researchers of genealogy, public library and archives professionals, private collectors, that this was an opportunity to kind of turn back the clock from a bad result in which law enforcement, who frankly don't know much about these kinds of archival materials, and certainly don't have an interest in keeping cultural heritage, accessible. Well, let's see if we can work around that so we get win-win situations. Let's talk about this in ways that don't only deal with ownership, but with stewardship, that don't only deal, that manage to think about both contemporary centers of Jewish life and countries of origin. And let's deal with ways in which the lack of information, the lack of knowledge, nobody has any idea how these items got out of Eastern Europe and how they eventually got to private hands. You can speculate. Some speculation is likely to be more correct than others, but nobody really knows. And frankly, there's no evidence for it. So how can we deal with the tension between wanting to work in an ethical market and also wanting to make sure that Jewish cultural heritage ends up in good, responsible public hands where it could be preserved and made accessible possibly. And basically what we were able to do through the cooperation of the National Library of Israel, through cooperation with the Association of Jewish Libraries, and through Jewish communal institutions in Hungary, was to arrange for a joint purchase in which the items were purchased off the auction by the National Library of Israel, in addition to the Jewish Museum, the Hungarian Jewish Museum and Archives. And thanks again for my colleague Zsuzsa Toronyi, who was also on the team, who at the time when I was still in the library, we worked on this together. And we were able to make a joint purchase, not only keep them in this solves all the problems, right? You can't really claim you've solved the problem of country of origin versus contemporary centers of Jewish life, because these items are jointly owned by the National Library of Israel and the Hungarian Jewish Museum of Archives. You've solved creatively the ethical problems of ethical considerations versus expanding collections by saying, we're bringing this back. We don't know what happened, but this is enough of a win-win situation for the stakeholders that we don't have to address all of those questions. And we found models that includes both ownership and collective ownership that help navigate and avoid the legal battles in which the only people who win are the lawyers and nobody else. So just as one last point, I know I've gone over the time that was given to me and I apologize. One last point quickly. You know why this is such a good win? Take a look at slide 6. Now we've got all this material from a particular region, and take a look also at this slide, the next slide, from this region in Hungary. Well, this is the same years. This acquisition by the Hungarian Jewish Museum and Archives works together with their ongoing attempts to gather materials from the town of Miskolc and other cities. And so what you end up getting is better metadata, better collections if you're interested in the Jewish community of Miskolc, better access, connection between these items and similar items that exist in the Hungarian Jewish Museum and Archives collection or in the National Library of Israel collection. And it's just a kind of win-win if you just are prepared to think out of the box and say, how do we think about not causing problems in provenance, but working together with all the stakeholders to solve them. I apologize for running a bit over time and hand the mic over to my friend and colleague, Michelle.
Thanks, Yoel. And echoing my thanks to Arthur and his part in this, his really good thinking here, and to the whole team. So I'm going to talk about a little bit about the practical piece that we put into the white paper. One thing to really make clear is that this is a working document for people directly impacted in the field. We're not lawyers, and well, we have a lawyer on our team, but we're not making specific judgments for specific cases. We're grappling with questions and we're making recommendations. And one of the things that we found when pulling this all together were a number of things that would significantly, I guess, make this landscape better. So one of the it should not have to be said, but sometimes it does, that you need to obey the laws, obey relevant laws, which mean different things to different people. We're trying to think about what standard protocols can look like. That's part of what we're trying to do here. Publicize available provenance information. This, again, should be a given, but it's not. It's hard to do. It requires advanced cataloging sometimes. But if you know something, make it transparent. And if we all agree to do this, then that will make all of our lives a whole lot easier. Again, it should seem obvious, return items to their legal owners or to their successors. Now, as Yoel pointed out, sometimes it's very difficult to identify who the legal owners are, because a legal case is actually quite difficult. Expand your collections responsibly. There are different ways to think about expansion of collections, and we hope that our colleagues, both in the private world and in the commercial world and in the library, in the more public world, will all agree to these recommendations. But I think what Yoel, the example Yoel brought, was a lot of this. When these Chaver Kadisha pieces came up to market, he reached out to Zusha. This was a matter of, when we talk to each other, we are stronger and we can have better outcomes. So let's try and make those lines of communications open in better ways. Another thing that became very clear was the importance of mediation. As I mentioned with number 4, and Agnes might expand on this, but creating a legal case, a legal chain of ownership, is incredibly difficult. Unless you have documents for every single stage of the way, it can be incredibly difficult to prove a legal case. When you bring a case to some kind of mediator, or it is so much more likely to actually come to a conclusion that is the best case scenario for all parties. Minimize deaccessioning. So I want to just make clear that what we were talking about the overall Judaica landscape. If you own something that is clearly owned by somebody else, please, by all means, go ahead and deaccession it and give it back to its rightful owner. We are talking here about when an institution owns an item, and it's publicly owned by that institution. Try not to deaccession it, because it can confuse the market when an item comes up for sale and somebody thinks it was stolen because it had been known to be owned by this institution. So just make it clear. So minimize deaccession if you can, and then make it clear that you have deaccessioned something if indeed you had to do so. Similarly, publicize theft. We understand, again, this is something that's difficult. There are stakeholders, there are donors. We don't want to look bad. We don't want to seem like we're not responsible caretakers. But if you publicize theft, then the thief has a much harder time actually selling that item, because everybody knows about it. And there are structures we discuss in the document where one can publicize this information. Building a metadatabase of provenance indicators. So what are signs of provenance? How do we identify signs of provenance? Some of us know some things. We're trying to compile all of our knowledge so that we can say, oh, well, I saw this stamp. That means that it went through Offenbach, or I saw this, this shelf mark, and that is uniquely the shelf mark of this particular library. So if we bring all of that data together, we can do better at identifying, at tracing the origins of particular materials. And then this, to me, is critically the most important. Historically, the different members of what I call the provenance ecosystem, or the Judaica book ecosystem, have sort of been in different silos. So we have librarians, we have curators that sort of work together. Then there's sort of the market people, or the people who sell those materials. And then there are private owners who own their collections privately. And historically, there hasn't been enough communication and trust between those 3 groups. And something that we would really like to try and build is a community of practice. We're all working in this same field. How can we work better together to make the field a stronger place, to make our work broadly more ethical, and to keep things sort of the way they should be? We really need to work better together. So what have we been doing so far? So the Association of Jewish Libraries has launched a task force on Nazi looted books. We just closed actually our survey of libraries. We have, if I'm not mistaken, 27 libraries that have responded, indicating that they're doing some kind of work to identify books that came from Nazi looting in their collections, and also to work on best practices. How can institutions that are interested in looking at Nazi looting in their collections deal with those collections? UCLA had a very public return of materials that they had in their collections, and they're now working on provenance, on protocols for searching provenance within your collection, what to do if you find something. More broadly, actually, not just within the Judaica context. Towson University is working on guidelines for provenance identification. So how to identify provenance. And I must include Bruce Nielsen's incredible guide to specifically JCR books, which describes what are the markings for books that went through the Offenbach depot, and how do you know that something came out of Nazi looting? So that's mostly within a Holocaust or World War II framework. There are many other frameworks that we're looking at. This white paper is not only limited to Holocaust theft of books. The upcoming Association of Jewish Libraries conference in June has 3 separate sessions with a number of papers dealing with provenance and books from varied collections from varied places, including a working session of how can we, as members of the AJL, which crosses some of those boundaries that I mentioned earlier, how can we work better together? And then, of course, international partnerships, working with institutions, certainly in the US, I know at my own institution and among broader institutions as well. Columbia is a member of what's called the Ivies Plus initiative, which is the Ivy League institutions and a number of others. And one of the things that they're working on is how to deal with provenance, not specifically relating to Jewish books, but broadly within, because these issues appear in all sorts of places. And how can we include this conversation? How can we be part of these broader conversations as well? So this is our flow chart. I just made we have some pieces larger, sort of what is low risk, what can make something quote unquote safe or safer to buy. When do you start to can be concerned, maybe consult with your legal counsel? When do you, and then when do you stop? When do you say this is not something I can acquire, or I need to take this up to the next step? Maybe I need to report something to the authorities. So we tried to make a really practical guide in this case of what stakeholders should do in all of these cases. And again, it's guidelines. We are not a governing body. We're not going to come and put sanctions if you don't listen to us. This is a community of professionals, and we're trying to work together. So I'm going to turn it over to Agnes to talk about the legal piece of things.
Thank you, Michelle. First, I would like to thank the Katz Center for the invitation. As a Penn alumni who lives abroad, it's a pleasure to be connected to the university again. Also, due to my professional obligations, I have to make a disclaimer here. While I'm in private practice as a lawyer, this presentation is purely an academic undertaking. I'm not advocating for a particular solution to any pending disputes, and all information about particular cases, if I will mention one, will come from public sources. So about our white paper. Most cultural institutions, cultural heritage professionals, and collectors have some access to legal advice. But many times, non-lawyer cultural professionals are required to make a first assessment of potential issues. Creating the white paper, we wanted to give assistance by listing the potential issues that could be researched even by a non-legal professional and could be considered. A qualified provenance researcher should be able to determine whether the provenance is complete, what we call airtight, or whether in most cases the gaps could signal legal problems. Again, our intention with including legal language, and even Michelle and Yoel used some, was not to give solutions to legal problems, but to draw attention to such problems and give guidance to be able to avoid mistakes that could lead to legal exposure in the future. Even if someone has the option to consult with a lawyer, expertise of legal advisors rarely include historical legal background on Judaica ownership. As a result, they may not know what to ask to assess the legal situation, and either do not recognize a potential issue or, finding it too complex, advises to avoid it altogether. In practice, instead of offering a roadmap to achieve the hoped outcome, legal counsels often advise to stay away from the potential problem. While the white paper's intended audience is cultural heritage professionals and private collectors, I trust that it would be very useful also for the legal practitioners, advising those professionals and collectors as well. Not only the section on best practice could guide them, but also the workflow diagram which you have just seen, which can be viewed as a legal due diligence checklist. The white paper could also be helpful for in-house legal advisors drawing up the institution's policy on acquisition and restitution. We also wanted to assure that we do not create a due diligence standard that could not be followed by the majority of our intended audience. National legal system could offer very different legal realities for ownership disputes, and we kept that in mind while drafting our recommendations. It is our hope that the white paper would enable the preservation of Jewish cultural heritage, as it should assist and not prevent responsible cultural institutions to acquire and care for our common Jewish heritage. To apply the title of our webinar, let's turn to the who, what, where, and how. First, who should be concerned about the ownership questions? Institutions, private collectors, cultural property professionals, including dealers and curators, all should be concerned about ownership questions, of course. The responsibilities of private collectors and cultural property professionals are easier to understand, but the responsibilities of institutions could be a bit more complicated. So I will mainly speak about those, and if you have questions later, we will of course answer. Institutions are complex entities, and responsibilities lie with several actors, heads of departments, board members, but not only those who have supervising responsibility, but even those who offer advice. Benefactors and donors should especially watch out for potential issues. Donors' gift agreements should include a section on what to do if an issue arises, who has the right to decide, and what decision could be made. In the past, most of the gift agreements would stipulate that none of the gifted object could be deaccessioned, which could be, of course, a major problem if restitution should be the advisable outcome of a dispute. And last but not least, board members of US charitable institutions have fiduciary duties that may or may not be consistent with the different guidelines the institution established on acquisition, deacquisition, and research. The most famous case about that conflict was the claim for Lucas Cranach the Elder's Adam and Eve at the Norton Simon Museum in California, who you may have read about it. It was in the papers at least for a decade. The board argued that their fiduciary duty is to keep the collection intact. So they were against restituting, and they embarked on a multi-year, multi-million-dollar legal fight. While the only direct relative of Norton Simon, who was also a board member in the beginning, argued that this would not be consistent with the original intention of Norton Simon. So according to the original intention, if a claim arises for Holocaust-era loot, these paintings, artworks should be given back. At the end, he left the board, and the foundation that is owning the artworks that are exhibited at the museum fought the lawsuit successfully. However, the cost, the publicity, and the moral fallout may make that success look more like a loss. Moral and ethical obligations cannot be measured only by financial value of the object, which is often the mistake of the board members. What should one be concerned I was dropped.
We lost you for a moment there. If you could just go back about 2 minutes.
I'm sorry. So I was talking about acquisition policy, that it's important to have one, and it's equally important to have the acquisition policy. Under what circumstances can an institution return a cultural treasure, and how to make room for creative solutions? Many founding articles have a difficulty with envisioning what a board would like to do part of a creative solution today. But I think that in most times, the board is able to reinterpret the founding articles, and they don't necessarily have to amend them to leave room for creative solutions. Another issue is loan policy. Local difference in laws make certain objects claimable or not claimable once they arrive at a foreign location. And claimable doesn't mean that the claim is justifiable or even winnable, but an institution needs to be aware that different laws would apply to ownership disputes once the object travels abroad. And then, of course, the institution should have a provenance research plan, which of course concerns the private collectors as well, as it would have an effect on future sales, exchanges, donations, since nobody wants to donate or inherit a lawsuit. And provenance research plan doesn't have to be a full plan of that we will research every single object in the collection. It should have a general idea of what could be considered red flag, what should be the priorities of the institution, and slowly but surely work through the possible inventory. About where, of course, where the objects are located today, in case on a loan, of course, in a foreign or in another location where the laws could be different, and very importantly, in the digital world. Today, a lot of the objects or their provenance or their scans are exhibited online, and it's very important to make sure that those information are properly listed. And the last question, how to minimize legal exposure. First of all, what I've spoken about at length is to establish procedures to spot potential problems. That's always the best, to realize that there is a problem before it's made public and make it larger than it should have been. There should be due diligence for new acquisitions, and there should be researching the collection with the prioritization regarding the red flags. We also included a provenance model that should assist with documenting the provenance reports. And last but not least, everyone should be aware of creative solutions and not necessarily go through a lengthy and very expensive legal process. Thank you.
Thank you so much, Agnes and Yoel and Michelle. I'm going to invite everyone to come back on together. There is a lot to think about and a lot to process in what you've just shared with us. There are a few questions from the audience already. I'll start with a few of my own mixed with some audience ones, and then we'll move on. So one thing that people are already asking about is to hear a little bit more about this relationship between stewardship and ownership and how it relates to digitization and digital access. For example, in a case of joint ownership, is there a recommendation to have a formal digital access agreement or a formal stewardship agreement that shares digitization? And how does that work out in practice?
So I can just say in this particular case that digitization was front and center in the conversations about those particular pinkasim. And in similar situations that I've been involved in, everybody, all the stakeholders have realized, at least all the stakeholders who have an investment in public access. Sometimes you have particularly private collectors who are not interested in that for reasons that are actually sometimes very strong, but but especially public institutions. There are some public institutions that also don't have that interest, but generally it's front and center. And once you are already at the stage of some kind of stewardship arrangement, something that's out of the box and not just beating your head against the wall to prove ownership, everybody realizes, or many stakeholders realize, that digitization serves everybody's interests because it gives more and more people access to it from a distance, because it allows, wherever the item is physically held, allows for other stakeholders to have at least digital access. And at the very least, although digitization is never a replacement for preservation, at the very least, it is a backup in case originals are damaged at any time. So both in that specific case, there certainly was commitment to digitization. The items are digitized and available both on the NLI, National Library of Israel website, and on the Hungarian Jewish Museum and Archives website. And in other situations, similar situations that I'm familiar with, there has certainly been an investment in that, and there are enough sites that are dedicated toward aggregating, having one or two digitized items on an obscure website is better than nothing. But the more these are available in large collections that people are going to be searching anyway, the serendipity of library searches, the better. And there are enough resources available to do that it tends to be also a win-win for lots of people.
Can one of you, maybe either Michelle or Agnes, talk a little bit about if there is resistance, or what kind of resistance is encountered to the idea of digital, either open digital access or expanded digital access in agreements like this? Are there, I think you all just referred to some private collectors who don't want to make things accessible for various reasons, but I wonder if any of you could talk a little bit about what that looks like. Like, it seems obvious, oh, we should just make everything available on the internet, right? That's all the problems are solved. What are the challenges with that? What do we face?
Sometimes it's, especially for more recent materials, so the copyright can be a real issue. If it's within copyright. Another thing that I was just discussing with someone was sensitive material. So even if it's about somebody's grandmother or great-grandmother, if it's recent enough that it tells a story that perhaps would embarrass that person, would, cause a rift in a family, something like that, we're sensitive to those kinds of issues. A sort of more mercenary question is, does it become less valuable? Our argument is, of course, no, it actually makes it more valuable when more people know about it. But there are certainly reasons, I would say more understandable reasons to keep things undigitized. But of course, I'm a librarian. I think everything should be accessible to everybody. I mean, that's what we do. We're about sharing information, but recognizing that there are cases where that's not appropriate.
I also think that it has a legal angle, because data protection law in the US and in Europe are drastically different. So you're not really allowed to publish personal information on the internet in Europe without express consent. And it relates to everyone who's alive, and to certain informations even for someone who's not alive anymore. So in the US, it's much easier to publish something, but then where is your aggregated, search engine located? So we have a lot of issues about that. One of the things that I often have is from the audience, it also helps to forge things, because the more information you put online, the more stamps, the more information of how would you recognize something, with the images included, then suddenly would see forged items having very similar looking, not exactly, but usually they're not that great, but similar looking stamps or inscriptions. So it has legal issues as well, besides the copyright, data protection, and again, what you achieve at the end. But I fully agree with Michelle. Whatever could be made public, I think should be made public, because this is right now we are talking about our Jewish cultural heritage. We're not talking about information collected about someone's internet search, because obviously that's a private issue, but we're talking about our common Jewish heritage.
Are there also legal concerns having to do with the stability or permanence of a digital sharing agreement? In other words, to many on just a gut level, it might seem that if you're holding the object in your vault, that's a different kind of ownership than if you have someone signed a paper saying that they'll let you see a picture of it, right? How does that play out legally? Or I suppose, Michelle or Yoel, if you've been party to these,
I want to sort of respond with maybe an extreme answer about physical versus digital. And I am the first person to say that digital is dangerous and you need really good preservation and you have to file transfers and all sorts of stuff that we're just only starting to grasp. But I always love to cite, I can't remember who it was, but at the turn of the century, there was an article written in a Jewish paper about how terrible it was that great collection of David Oppenheim is out in the boondocks in Oxford and is not in one of our wonderful German institutions, and it's so hard to access because it's all the way out in Oxford and not in Germany. And of course, hindsight is 2020. So just because something is owned physically, the world is a complicated place. So just sort of to flip that question, it is a very valid question, and this question of digital versus physical is a good one, but physical does not always mean protected. I mean, we've seen libraries burn in the last 2 years. We've seen physical loss in many ways as well.
For sure. Thank you for that. Agnes, did you also want to answer?
Yeah, I usually advise when there is an agreement on digital publishing, on who's going to maintain that publishing site, and how often do they upgrade the search engine, etc. Because things can, in basically 10 years today, even if you just do small maintenance, after 10 years it's basically gone. So that's a major question. And when we're talking about databases, creating databases, making lists, we are always very conscious about who should be the owner of that database, because the owner of the database has a responsibility to maintain it. But of course, the owner of the database decides what's going to be published, for how long, and in what form. And at the end, regarding fine art, which with some of the books and other items included, the German government maintains the Lost Art database for Nazi-era looted objects. There is an entire institution behind it. There is government commitment. So we hope that a database like that will survive the age. But we always have to be careful about where to place our trusted digital archive as well, because it could burn in some digital way.
And the other thing about digital is that it could be duplicated.
Yeah.
So you could have multiple institutions in multiple countries owning copies of those digital images and committing to take care of them.
I also wanted to ask about relative cost, right? So someone put a question about where you get the capital to do the digitization. There's also, of course, cost involved in housing and preserving physical objects. And so I just don't actually know, as someone who's not a practitioner in this field, what is more expensive? How do you manage what seems like more of an obstacle to institutions that are looking to expand their holdings?
Well, no public institutions are rolling in money, as far as I can tell. And when I was involved in collections development for public institutions, I was at the National Library of Israel, which has a very, very expansive collection policy, and by the standards of things has significant routine special collections, rare items budget. The question I always ask myself is, how much knowledge do we get per dollar? And very often there are, because it's simple supply and demand, right? If people who own investment banks are interested in item X, then the public institution is not going to get it unless those people donate it. But there are often real holes in the market, or places where private collectors are less interested because it's not beautiful, because it's not as accessible, because it's in obscure languages, because it doesn't happen to be in faddish right at the moment, where public institutions can step in and say, this looks obscure and bizarre to a lot of people, but add it to a collection, and it starts being a data point in a number of different kinds of research dynamics. I'm thinking of Pinkasei Chevra Kadisha are a good example, where you're not talking about 5, 6, 7-digit items. They sometimes only a few $100s, maybe more. Well, get enough of those together and you have a really fantastic data set. So how do we position ourselves as public institutions in the market such that we are making maximal contributions to public knowledge without competing beyond where we can compete as public institutions?
Also, I want to just address the digitization cost question, because those are big costs, and server costs are not negligible and maintenance costs are not negligible. And I think this is something that realistically libraries are grappling with. And part of, I think, putting this together and encouraging digitization means also that we need to turn to people who are concerned about this, in maybe foundations that are concerned about cultural heritage, to say the digital is something that's a piece of that as well. And how do we preserve it? How do we preserve things digital? How do we digitize them so that they can be accessible? I would love for that to be on the agenda of major funders as well. And I think that's part of what we're flagging here in talking about digitization.
I actually fully agree with Michelle and also with Yoel, but my main concern is that the digital world didn't make things cheaper. And I still remember when we were told that, I started out as a lawyer with typewriters. So we were told that once, the digital world will come, we wouldn't have to have all this paperwork, the archives, the this, the that. And today we basically double everything. And the costs are doubling, because it's true that it's cheaper every year to store the same amount of data. So we just make a better quality scan. And it's not, we had the microfilms, then we scan them, then we just in one of the institutions I work with, they just rescanned everything because the scanning facilities are so much better. So yes, it's cheaper by megabyte, but we just have much larger files. So my problem is that it's an enormous cost. It's a daily review, because digital files are maybe even more prone to damage than a paper library. So I'm just worried about how we will be able to maintain, not to talk about the electricity cost. I mean, it's horrendous. So anything that comes with our digital life and digitization is very, very expensive and has a major effect for our future.
Thank you. I am going to suggest that we zoom out a little bit. I want to ask some broader questions to the extent that any of you are willing to talk about them. Thinking about how in the news over the past few years, there have been a number of well-known examples of objects in dispute, either held by museums or libraries, whether in terms of how they're presented and displayed, or just literally where they are and who owns them. So the elegant marbles, right? Or very recently, there's an update to the 1990 law on Native American artifacts. And so a big exhibit at the Museum of Natural History was closed, right? So I want to flag that there is a lot of commonality, I think, in the kind of underlying ethical and broader cultural issues involved in what you guys are working on here, and try to get at some of that. So first of all, I'm wondering to what extent this particular white paper effort has been driven by a sense of similar concerns of needing to address bigger problems rather than specific sort of legal or policy-based institutional concerns. And has this effort been in conversation with provenance professionals working in those other communities and those other areas?
So yes and yes and no.
Okay.
Great,
we're done.
The discussion came up partially because of actually on the ground questions that I and my colleagues were fielding, either professionally or as consultants or, in various capacities. So it came up because this is an active issue in the field of Judaica. But yes, the fact that it's also a broader issue spoke to what we were talking about as well. I would also add that absolutely we've had interest from not specifically Judaica, outside of the Judaica world in the work that we're doing as a model. Now, part of the reason, and we say this very clearly, is that our white paper is only about Judaica. We are not going near any of these other areas. That's not our expertise. We are talking about the field that we know. But we are happy to, talk across. I think that we gain a lot from talking with one another about these kinds of questions. And yes, that's been happening.
I think it has a sort of a longer history because in 1998, there was a conference in Washington that dealt with Holocaust era assets, and everyone remembers that it was the conference on Holocaust era looted art. Well, looted art was just a small part of the conference, but that basically survived because of the Washington Conference principles. And that was a guideline of how to deal with Nazi era looted art in general. And we used the word art, but everyone meant cultural property. And as a result of the Washington Conference, a lot of things happened later on. One was the Prague Conference, which issued the Terezin Declaration. And the Terezin Declaration was the first guideline when actually Judaica, books and archives, got a different section, because we realized that there are particular issues to Judaica books and archives that are different from fine arts. And therefore it had its own section. And since then, I think this was in 2009. And since 2009, I think there are a lot of movements in conferences, in professional organizations of how to develop provenance research more in this field, and how to help the professionals, how to guide the professionals through this process, which accumulated in the white paper now. But everyone have been, I think, in touch with the practitioners of all the other fields, especially that many viewed our work as the first example to articulate our field this way. And they look for ideas from us, and then they, apply it in the other fields. So I think it's a very good process, because we are in touch with the different practitioners in the other fields, and I think we both gain a lot from these discussions.
So I want to add in one sentence that a lot of this came out of a sense of people in the field reading and hearing what was going on and saying, that's really, it's these things are getting on the agenda, but that's not really helpful for me, because it's coming, let's say, out of a paradigm of colonial theft. And I'm dealing with things that were, that were smuggled out of a country when Jews were expelled. That's not quite the same, even if, there are moral considerations that overlap, but it's not helpful to me. Or there might be material on paintings that are worth $100,000 or $1 million, in which it's really worth investing. Well, what about a 100-year-old book that's worth $50? And not that something unethical becomes ethical because the item is less important, but we have limited bandwidth. So how much am I going to invest in researching an item that's not that rare and not worth that much, and where the likelihood of getting good information is pretty slim. So we kind of felt like there's a lot to learn from so much that's going on in provenance in the last, let's say, generation and a half. But not all of our questions have been answered.
Yoel, you just anticipated my next two questions, which is fantastic. I want to kind of see if we can expand on one of them, which is that there is a difference, an obvious difference between the kinds of things that we're dealing with in the world of Judaica, rare Judaica, and the examples that I named. In that it's not a colonial context, in that you're largely talking about Jewish books and Jewish institutions and Jewish libraries, right? And yet, I wonder if there are any
just if I can interrupt the question and say that we're talking also about non-Jewish institutions that hold very significant Judaica collections. And as Michelle mentioned before, like Oxford holding materials, thank God they were in England and not in Germany. Sorry for the interruption.
No, that's okay. So that was actually half of my question, is how does that play in, and how is that different from dealing with specifically Jewish book or books or collectors? The other half of my question is, even in dealing within like the National Library of Israel or the Association of Jewish Libraries, are there also parallel disparities of power or economic imbalance that make these issues more difficult? So it's not a colonial context, but there are relatively disadvantaged or minoritized communities even within the Jewish world that might be having a harder time finding restitution or having their voices heard. So whichever half of that you want to speak to. Yoel, do you want to start since you took us there?
Sure, but you're asking a really, really hard question. There where what we're trying to do is create win-win situations. What we're trying to do is stay within the law, stay within the boundaries of ethics, and continue to make sure the Jewish cultural heritage is accessible, protected, and available to the people who can use it effectively. And in the real world, there are huge imbalances between the wealthy and the weak, between those with government backing and those without government backing, institutions with legal standing, institutions without legal standing. And I kind of feel like we're trying to stay in our lane here. We're not going to be able to address global questions of power imbalances when it comes to cultural heritage or wealth distribution in general. But one of the things that was really lovely, again, going back to this example of the Pinkasim, was that it was a cooperation between a wealthy collector individual, a public institution with a relatively large budget, and a public institution with a relatively small budget. And goodwill goes a long way when you're dealing with a specific situation. It doesn't necessarily help the structural issues, but that's way beyond our pay grades. But goodwill goes an enormous way in improving concrete situations on the ground, and that goes back to the community of practice that Michelle was talking about, because that's where that goodwill is found. It's not found in contracts. It's the contracts will be a consequence of the goodwill that's found with people schmoozing over coffee, to put it, concretely.
Great. Certainly not found in the courtroom.
if I may address the first part of the question, I think there is a major difference, because in looted art objects, the objects are quite many times are with the looters or with the heirs of the looters in one way or another. And in our context, they aren't. In our context, they came from a Jewish community or from a Jewish collector or from a Jewish institution. And then there were someone else most of the time who did the wrongdoing. I'm not talking about contemporary theft, because those are many times done by in-house, as we know. But the historic ones aren't. And they end up at institutions who want to save our joint cultural heritage. So I think the balance in that sense is quite different when we talk about historical theft and displacement in Jewish cultural context.
Thank you. Michelle, do you want to weigh in on this at all?
No, I think Yoel and Agnes just put it really well. It's, yeah.
Fantastic. Well, in that case, I think we'll wrap up. I want to thank all of you very, very much, not only for being here with us today and sharing all of this, but also for doing this work and putting in the years of effort to get a community of practice going. It definitely seems like from the audience that joined us from the beginning of this program, it's clear that there is a community of interested people out there. And so I wish you very, very good luck with the rest of this process. And once again, thank you.
Thank you so much.